Good morning. I am Jayashree from Institute of Sai. I take classes for Judicial Services. Okay, we have been doing CPC and we have completed up to section 59. So now we'll be starting with section 60. Okay, the heading of the section 60 says attachment. So as we already know what is attachment, attachment is of properties either when money is not paid. Usually it is like when money is not paid, there are properties which are attached. Okay, so now let's go to the section 60, the heading of which says property liable to attachment and sale in execution of decree. Okay, what is a decree? It is the final order given by the court. Okay, it is the functional order, basically the operational order which is given by the court is known as decree, right? So in execution of a decree, when the final order is given, the operational order is given by a court, okay, in for execution of that particular decree, see, as I already told, money would not have been paid, repaid rather, right? So when money has not been repaid, obviously there will be a case which will be filed before the court. So once the judgment is given, judgment and decree, the operational part becomes the decree. So in execution of the decree, as a implementation of that particular decree, what shall be done? There shall be attachment and oblique or sale of property. See, sometimes what happens, property will be attached, okay, but as soon as the property is attached, some of the parties come out and they pay the money. So therefore the attachment order is also cancelled, right? So but sometimes what happens, the parties, either party do not have any money to pay. So what do? There is an attachment and sale of the property, right? So there is a decree in execution of which, in implementation of which, there is a attachment and sale of property. Now when we say property, it can be movable property or immovable property or both. Clear? So, I mean, if the amount is huge, obviously you will have both, right? Movable and immovable property. Sometimes the movable property suffices. Sometimes only the immovable property suffices. So however it is, when there is an implementation of decree, there can be an attachment and sale, provided the court has directed for attachment and sale of property. That is very, very important, right? So what are the properties which can be attached? As I already told you, movable and oblique or immovable property. Either both movable and immovable, or only immovable property, or only movable property, right? Now we go to the exceptions which cannot be attached. See, this is very, very important, okay? Because not everybody is in the same profession or same job, or, loans are being taken by so many other people, right? So there are variety of functional jobs, right? So, which property can be attached, which cannot be attached? Which property can be attached, we have already seen. Which cannot be attached, we will read now as is given in the book. Okay. For example, you can take up the necessary wearing apparel. Apparel means what? Clothes. Okay. So, whatever are the clothes for personal use, whatever are the items which are kept for personal use, cannot be attached, such as wearing apparel, cooking vessels, okay, beds, bedding of the judgment debtor. Now, who is the judgment debtor? Against whom the decree has been passed, against whom it has been ordered by the court that the property shall be attached. Such a person owes, according to the judgment, the person owes the money to other person. Therefore, is called judgment debtor. Right? The other party is known as decree holder, the one who holds the decree, okay, because the decree is in his favor, okay. Now, the necessary wearing apparel, cooking vessels, beds, bedding of the judgment debtor, wife and children. See, again, we go to ethics, right? And such personal ornaments in accordance with religious usage cannot be parted with by any woman. Okay, so here what do we have? Wearing apparel, cooking vessels, beddings, ornaments according to religious. See, now there are people who have only basic necessary ornaments. There are people who hoard ornaments because they think that They need it at a particular period of time. They may need it. Therefore, only those ornaments which are necessary and which are being used for religious purposes, only those ornaments cannot be attached. Other than that, any other extra ornaments or anything like that can be attached. Okay, so because everything cannot be religiously attached with, right? So those ornaments can be attached. Clear? Number 2b, tools of artisans. And where the judgment debtor is an agriculturist, then whatever are the tools of an farmer, right? So tools of artisans, we have various artisans, where some people are sculptors, some are, probably they are into constructions, whatever it is, some are into paintings. Of course, painting doesn't come here. Sculptors and other artisans. You have the interior decorators, they have lots of tools. So interior decorators make use of the artisans, right? So whatever are the tools which belong to artisans, they cannot be attached. Clear? And one more thing, where the person is a judgment debtor is an agriculturist, he is a farmer by profession, okay, then his tools cannot be attached. His implements of husbandry, cattle, seed, grain, okay, I mean, these are all necessary for his daily usage, right? For his livelihood. Therefore, these cannot be attached. Anything which can be used for earning his livelihood. See, whatever, basically, when a person is not repaying, obviously it is because he doesn't have money. So, even if the basic needs are not being met by him, then it would become difficult for the person, right? So, whatever are necessary for the living and livelihood of a person cannot be attached. That's the simple logic behind this particular section. Okay? Now, where the judgment debtor is an agriculturist, then his implements of husbandry and such cattle and seed grains as in the opinion of the court be necessary to enable to earn his livelihood, and such portion of agricultural produce. See, you should understand, even the produce, a certain quantity of the agriculture produce also cannot be attached. Okay, because he will need it for his own use. So, per such portion of agriculture produce or of any class of agricultural produce as may have been declared to be free from liability under the provisions of the next following section. In section 61, we will see. Okay. So, agriculture produce, a particular quantity and the type of agricultural produce which cannot be attached. We will see that in the next section. Okay. Then C, houses and other buildings and the land immediately appurtenant thereto and necessary for their enjoyment belonging to please underline this, okay, belonging to an agriculturist or a laborer or a domestic servant and occupied by him. Please underline the words belonging to. Why? Because all of us have houses. Some of them have bungalows, right? Some of us have bungalows, some of us have flats, some of us are in independent houses. Whatever is there, we all have lands. Everything is there, okay? But just because we have not repaid a particular loan, it doesn't mean that we have to these assets cannot be attached. Okay, here we are not talking about the assets which every person has in his life, right? It is not that every flat, every bungalow, every house should not be attached. That is not the case here. What is the case here? Which belongs, either it can be a building, it can be a land, but it should belong to a laborer or an agriculturist or a domestic servant, and it should be used by him. See, again, underline the word used by him, occupied by him rather, right? So occupied by him, you please underline that. Why? Because only if it is occupied by him, it is taken as for personal use. Am I right? Earlier also we have seen whatever is needed for personal use, that cannot be attached. So same way, the land or the building which is occupied by him cannot be attached. Okay. Other than that, if he is having any other land or any other building or something like that, then that can be attached. Okay. So you should know the basic difference. That's why I'm stressing upon all these points. Okay. Then next, books of accounts. See, for any business person, books of accounts is Very important, right? And we have already seen in Evidence Act, books of account is a part of evidence, right? So that cannot be attached and sold as such, okay? Because it doesn't, of course, it is very necessary for a business person. And more than that, if there is books of account which is sold, there is not going to be any benefit also, right? So books of accounts. Then mere right to sue for damages. What is damages? We know it, right? We have seen in Contract Act. Damages means compensation, right? So a mere right to sue for damages. Mere right to sue for damages. See, I may be having a say probably I may be having a check, okay, and the check would have surpassed its period. So I am trying to file a recovery case, okay, because check bounce case cannot be filed, so I am trying to file a recovery case. I have the right to file a recovery case, but can my right to file a recovery case be attached? It cannot be attached. Am I right? Because nobody can attach rights and duties, right? So, right to sue, a mere right to sue for damages cannot be attached. Clear? If I have filed a recovery case and I've got money out of that case, then that money can be attached. But mere right to sue for damages cannot be attached. Then, any right of personal service. Any right of personal service means I have a right to get any personal service done by anybody. So again, it comes to the matter of right. Can a right be attached? No, it cannot be attached and sold. Right? It cannot be attached first of all, then only sold. Okay. The next one, stipends and gratuities allowed to pensioners of the government. See here when we say government, it includes state government, central government, local authorities, anybody, any government departments, anything, whoever gets a pension, right? So payable out of service family function, service family pension fund notified in the official gazette by the central government or the state government, and political pensions. So pensions of any type cannot be attached and sold. Why? Because it's a social welfare measure. See, when you're reading for judicial services or anything, any course for that matter, always remember law should always be followed in entirety. Okay. So why you think pension should not be? I mean, you're going to become a judge, so you should have all the, you should have the analytical thinking, right? So why do you think pension should not be attached and sold? After all, it's a amount, right? When we can attach any other amounts, why not pension? It is only because pensions is a social welfare measure, right? It's a welfare measure under the Labor Act also, right? Okay. Then the wages of laborers and domestic servants, whether payable money or in kind. So laborers and domestic servants. Why so? Because it is very necessary. Only when they get the money what they have earned, only then they can live, right? It is a right to live basically. So those wages which are got by the laborers as well as the domestic servants, first of all, it is only minimum wages. We should think about that. So that also cannot be attached. Salary to the extent of the first 1000 rupees and 2/3 of the remainder in execution of any decree other than a decree for maintenance. So salary can be attached, but up to what extent? Salary to the extent of the first 1000 rupees and 2/3 of the remainder in execution of any decree other than a decree for maintenance. So this cannot be attached. Salary to an extent of 1000 rupees and, please underline that and over there because it is not or. Okay. So first 1000 rupees and 2/3 of the remainder. So 1000 rupees cannot be attached. Apart from that, whatever is amount, in that amount 2/3 of the amount cannot be attached. So basically what is the meaning? 1/3 of the remainder amount can be attached. Clear? Provided that where any part of such portion of the salary is liable to attachment has been under attachment, whether continuously or intermittently for a period of 24 months, such portion shall be exempt from attachment. So what shall be exempt from attachment? If a particular, that 1/3 portion, right? if it has been attached for a continuous period of 24 months, then such portion shall be exempt from attachment until the expiry period of further 12 months. So, one third of the amount has already been executed, has already been attached for 24 months, right? That is 2 years, right? So, when it has already been attached for a period of 24 months, then it should not be reattached for a further period of 12 months. That is one more year. It should be left free. And again, the attachment can happen. Okay. And the further attachment can again be for 24 months. No problem. One third of the salary in execution of any decree for maintenance. Okay. So, one third of the salary in execution of any decree for maintenance. So, one third can be attached. The pay and allowance of persons to whom the Air Force Act, Army Act or the Navy Act applies. So, pay and allowance of the defense forces cannot be attached. All compulsory deposits and other sums in or derived from any fund to which the Provident Funds Act for the time being applies, in so far as they are declared by the said act not to be liable to attachment. Again, PF cannot be attached up to the extent which the PF Act says cannot be attached. So, for the purpose of PF, it is not a general rule under CPC, but whatever is the amount which is mentioned, say a particular percentage would be mentioned under PF Act, right? So, that particular, according to the PF Act, whatever is the amount which can be attached by the court under CPC. Okay. All deposits and other sums in or derived from any fund to which the Public Provident Fund Act for the time being applies in so far as they are declared by the Act as not to be liable to attachment. Here it is again the same thing, only difference is the Employees Provident Fund and the Public Provident Fund. Okay. All monies payable under a policy of insurance, life insurance, it is not vehicle insurance or anything like that. Life insurance, whatever is the money which is payable on a policy. Okay. So, suppose one person has been paying premium. Okay. And the policy has become due at a particular stage of time. Okay. In that case, whatever is the amount which the person gets out of the life insurance policy, that cannot be attached. All the interest of a lessee of a residential building to which the provisions of law for the timing in force relating to control of rents and accommodations apply. See, lessee, interest of a lessee of a residential building. Lessee, who is a lessee? Is a tenant, right? So, what happens during lease? If we take it for say 2 years or 3 years or whatever, we pay a bulk amount. We don't pay monthly rent, am I right? So, whatever is the interest which is accrued by the owner on such lease amounts shall not be attached. Okay. Provided that particular interest comes under the Rent Control Act or other applicable laws in that particular state. Any allowance forming part of the emoluments of any servant of the government or of any servant of a railway company or local authority which the appropriate government may, by notification in the official gazette, declare to be exempt from attachment, and any subsistence grant or allowance made to any such servant while under suspension. So, what is it? Any allowance which is part of the emolument. So, salary can be attached, right? Only those which are allowances, for example, dearness allowance, house rent allowance, you have so many such parts, right? So, all these allowances cannot be attached. Same way, any person, any government employee who has been suspended, he'll be getting certain subsistence allowance, right? To help him sustain during that particular suspension period. So, even that subsistence allowance also cannot be attached. Okay. An expectancy of services by survivorship or other merely contingent or possible right or interest. Again, we have already read about right to sue for damages and all that, right? So wherever there is a right, similarly, when we are talking here, any expectancy of succession, it is a right. Am I right? I am expecting to succeed to my father's property. Can the court attach my expectancy of succession? It cannot, right? Because it is more like, contingent contract, may or may not happen types, right? So, mere expectancy of succession cannot be attached. A right to future maintenance. We have already read all this in Contract Act. Please use that knowledge to apply this. Okay. Now, right to future maintenance. Whenever we are expecting a maintenance amount in future, again contingent contract, right? May or may not happen. Future, whatever is there, it cannot be taken to be subsisting. Clear? So future maintenance, whatever is the right to future, I may get it. Okay. So even if I'm going to get it in future, that right cannot be attached. Any allowance declared by Indian law to be exempt from liability to attachment or sale in execution of a decree. This is more of a general character. Am I right? So any allowance which has been declared by law itself as not being liable to attachment cannot be attached. Where the judgment debtor is a person liable for the payment of land revenue, any movable property which under any law for the time being applicable is exempt from sale of recovery of an arrear of such revenue. So where the judgment debtor is liable for payment of land revenue, then such particular amount cannot be attached. Clear? You have certain explanations there. You can go through that because I've already explained it to you. You can just go through that and then see how you can understand it. Okay. Then explanation 6. We go to explanation 6. It's the same thing, by his own labor. Here what is written is agriculturist, about the work that he does. So you can look at the explanations. If you are finding it a little difficult to follow, then we can get back. Okay. Now we go to section 61. Partial exemption of agriculture produce. We have already read in section 60 about a particular portion of agriculture produce which cannot be attached, right? So we are going to read about that now. So see this particular section, whenever is the whatever is the quantity which has been directed by the state government or the central government not to be attached. Okay, it's usually the state government. So whatever quantity the state government gives a direction not to be attached cannot be attached. Till what time how will they determine the quantity? That's the question here. Am I right? So how will they determine the quantity of the produce? The quantity of the produced is determined based on how much will be needed. It is not a matter of want. It's not a matter of desire. Remember, how much will be needed for the agriculturist to exist till the next harvest season. See, they depend upon harvest to harvest. Am I right? So, how much quantity of grains will be needed for them to last till the next harvest season? So, that particular quantity will be exempt from attachment. Clear? Then next we go to section 62. Seizure of property in dwelling house. Okay. Seizure of property in dwelling house. Seizure, what all can be attached, what cannot be attached, we have already seen in the previous sections, right? The previous 2 sections. So, how to seize it? Next question. That's the next step, right? How to seize whatever is there in the dwelling house. Dwelling house means what? Which is occupied by the judgment debtor. So, how to seize the property? Okay. How to seize the property? Number 1, first of all, there will be a notice which is given by the court. Okay, saying, informing about the attachment. Other than that, no door can be broken open in order to seize. Okay, that is very, very important. So please keep it in mind. No person executing any process under this code directing or authorizing seizure of movable property shall enter any dwelling house after sunset and before sunrise. See, if you are looking at CRPC also, you have the same thing. No arrest of a woman can be made after sunset and before sunrise, right? So, I mean, that's an exception, but I just want to tell you about that so that you keep in mind everything. That's all. Okay. So, here also, when there is something called the seizure of property, no dwelling house can be no assets can be seized from a dwelling house after sunset and before sunrise. So it should be made only after sunrise and before sunset. That's the general rule. Okay. The next one, no outer door of a dwelling house shall be broken open unless such dwelling house is in the occupancy of the judgment debtor and he refuses. Please underline that. He refuses in any way or in any way prevents access therein. So, just like that, because the judgment debtor is not at home, then the house cannot be, the door cannot be broken open. Clear? It can only be broken open if the judgment debtor is trying to stop access to the executors. Okay? Or he is trying to, just not open the door. He is trying to escape from there. Okay? He is trying to escape the attachment. In such cases, the door can be forcibly broken open. Clear? Where a room in a dwelling house is in the actual occupancy of a woman, then what should be done? Sufficient notice should be given to the woman saying that the woman has to go to another place so that whatever are the items in the room that can be seized. So sufficient time should be given to the woman to move away from that room. So obviously notice has to be given, right? So it is not a written notice or anything when I say notice. Just that they are going to break open the door or open the door or whatever. So she has to go somewhere else. That's it. Okay, then next we go to section 63. Property attached in execution of decrees of several courts. Okay. So what will happen? See, there are several courts. I mean, you must be knowing about many cases like that. Am I right? Where the the decrees of, there are several courts which have passed decrees against one particular judgment debtor in different cases, right? So in such case or in the same case, the decree judgment debtor has various properties. So whatever is the type of situation where there are many decrees which have been passed by various courts, not the same court, mind you, various decrees passed by different courts, then how will the execution of decree start? Okay, every court has passed a decree for execution of the decree. Then how will the attachment be? Which court will take up the responsibility for attachment? The court of the highest grade will take over the attachment of the properties. Say for example, there are few taluk level courts which have passed the order, the judgment and decree, and there are a few of the district courts, rural side or urban side, whatever you want you can take. Okay, there are a few district courts which have passed the orders. So obviously whichever is the court of the highest grade among these taluk and district courts which have passed the decrees, that particular court shall take up the attachment of the property. Clear? We will stop with this. We have just one subsection. Nothing in this subsection shall be deemed to invalidate any proceedings taken by a court executing one of such decree. Even if any other court takes up such execution, it will not be taken as a invalid attachment. Why is it so? Because it is basically only a technical irregularity. Again, we go back to Evidence Act. Am I right? Which the end of the Evidence Act, you have technical irregularities which can be rectified and the other types of irregularities. Am I right? So this comes under the technical irregularities. Clear? So just because some other court has executed the decree doesn't mean that it is an invalid execution of a decree. Okay? We will stop with this. We'll continue in the next session. Thank you.